to mention item number 11, my lord, of the hearing list. My lord, I pray it may come up after 4 weeks, my lord.
Yes, my lord, no objection.
On premier by the appellant, this is matter up to 4 weeks.
Deeply overruled.
May please, Your Lordship. Your Lordship, I beg to mention item number 13, Your Lordship.
Number?
13, Your Lordship.
You're for.
I'm for the state, Your Lordship.
I'm for the petitioner, Your Lordship. No objection.
On premier by the state respondent, not objected to by petitioner. This is matter up to 3 weeks.
Obliged, Lordship.
Lordship, I beg to mention item number 9, Your Lordship.
No objection.
What is 9?
Departmental proceeding and termination, my lord.
Or it. Municipal matter?
Yes, my
Garo
lord.
Hills.
Bagmara South Girls.
Bakura. On premier by the petitioner, this is matter up to 3 weeks.
Sure. Obliged, Lordship.
May it please, Your Lordship, I beg to mention item number 14, my lord. I'm appearing on behalf of the petitioner in this matter, my lord, as the conducting counsel Pinongri is indisposed, my lord.
Who's for the respondent?
Sadeep Nath.
Have you talked to him?
I went to look for him, my lord, but he is not there in his room. I'll be informing him, my lord.
Let it be called. Let it be called up, otherwise, he may come and say that I have not consented.
Okay, much obliged.
Please, Your Lordship, I beg to mention item number 6. Let this matter come after 2 weeks, Your Lordship. As we are yet to receive the RTI reply, Your Lordship.
2017 matter.
Yes, it has been heard, but then we have filed for RTI, so we are yet to receive the reply, Your Lordship.
On premier by the petitioner, this is matter of 2 weeks.
Your Lordship, I beg to mention item number 15. For 2 weeks' time, Your Lordship, since the conducting counsel is not available due to some personal difficulties, Your Lordship.
On premier by the petitioner, this is matter of 3 weeks.
May I please, Your Lordship, I beg to mention item number 7, Your Lordship. Your Lordship, let this matter come in the first week of August, Your Lordship.
Why?
The conducting counsel, he is from Kirti. He said he is on summer vacation, so he went to his hometown.
No objection.
On premier by the respondent, you are for bank.
Yes, Your Lordship.
Respondent, Bank of India, not objected to by petitioner. This is matter up to 4 weeks.
Lordship, I beg to make a mention for item 8, Lordship. Operated matter may come after 2 weeks, Lordship.
Is there? On premier by the petitioner, this is matter of 3 weeks.
Fully obliged.
May I please, Your Lordship? I beg to mention item number 10, Your Lordship. My senior is, due to personal difficulties, will not be able to appear today, Your Lordship. May I pray humbly that this matter be taken up after 2 weeks?
You are for?
For the respondent.
Respondent what? Only one respondent?
Number 10.
Who's respondent 10?
Sir, from Cantonment, sir.
Petitioner?
Lordship, I'm for the petitioner.
Because item number 12 is connected.
So if 10 is adjourned and 12 too? On plea made by the respondent on grounds of personal difficulty of the learned conducting counsel, matter is adjourned. List the same after 3 weeks.
Much obliged, Your Lordship. Obliged, Lordship.
So that's 10 and 12.
10 and 12, Your Lordship.
Daily course list, item number 1.
Please, Lordship. This is an application under section 482 minutes filed before Lordships, challenging the proceedings of my Lord's CR case number 96S of 2021. This was filed by the respondent, my Lords, before the Judicial Magistrate First Class Shillong, my Lords. And by order dated 18/7/2022, my Lords, cognizance of offences have been taken by the learned Judicial Magistrate. Well, it's just 2 very short points on which this revision petition is there before your Lordships. Well, it's a perusal of the averments in the complaint, and I'll take your Lordships through that. Show, my Lords, that the dispute between the parties or the alleged, because at this stage, my Lords, I will have to only satisfy your Lordships with regard to the allegations made. The alleged offences have all been committed in New Delhi. The only part, my Lords, which they say connects Shillong to this offence is that a power of attorney was executed by the respondent number 1, respondent, my Lords, in favour of the petitioner number 1 in Shillong in the year 2012. Both the parties here are brothers, my Lords. It is apparent from the complaint filed before your Lordships, my Lords, that it is a family dispute concerning property and monetary issues between the parties. And what has happened is, my Lords, a criminal case gets to be filed in Meghalaya, and, my Lords, absolute non-speaking order, the learned court takes cognizance. Now, I'll very quickly first take your Lordships to the complaint. If your Lordships kindly have, my Lords, page 35.
$25.
35, my Lords. 35. Your Lordships may directly come to page 36, my Lords, paragraph 5, last 2 lines of the page.
Yes.
Paragraph 5, your Lordships have it, my Lords?
Yes.
That your humble complainant is the owner of a freehold land bearing plot number C75A measuring 150 square yards out of Khasra number 351, situated at Colony Mohandru Enclave, Block C on GT Karnal Road near village Milakipur Chowni, Delhi State, Delhi 110033. Having initially, I'm sorry, my Lords.
Yes, yes, please go ahead.
My Lords. Having initially a room and boundary wall from one Shri Narendra Kumar by GP are not relevant, my Lords. I'll take your Lordships to paragraph 6. That as stated above, accused number 1, Deendayal Sharma, used to visit Shillong occasionally, and in one such visit in 2012, he made a proposal to your humble complainant in May 2012 in the presence of her husband Shri Ramesh Sharma and their son Shri Mohit Sharma, that when there is a plot of land in Delhi since March 1999, and when such land can be developed by raising structure over the same by giving it to a developer as was the system in vogue, and the complainant became impressed with the proposal so made by the accused number 1, and at his instance and instances more so, he being the own younger brother of her husband, and as such to equip the accused number 1 with a legal instrument, had executed a general power of attorney duly registered with the sub-registry at Shillong, Meghalaya on 21/5/2012. investing bona fide 100% ownership right over the said plot of land situated at Colony Mohindru Enclave Block C on so-and-so, my lords, then the schedule is given. Then very interestingly, my lords, this second part of the paragraph, I'll just read it because that will be very relevant for our purposes. It would be appropriate here to mention that in the general power of attorney dated so-and-so, as stated above, your humble complainant empowered accused number 1, Deen Dayal Sharma, with the power as contained in clause 1 to 13, by which almost all her right over the said land, including the power to sell, lease, mortgage, and transfer as well, was given with a bona fide intention and suggested by him in good faith, so he does not face inconvenience while dealing with the developer, contractor, and other statutory authorities, including general power of attorney dated being her title to the land in the matter of construction of RCC building flats over the land having so-and-so, so-and-so. In short, the deed of GPA dated so-and-so registered in Shillong, Meghalaya was executed on the understanding that the developer would provide 2 flats standard size with bathroom, toilet and balcony, etc. on the 1st and 4th floor of complainant, and the developer would take 2nd and 3rd floor on the same. Very important, my lords. Other matters in this regard will be as per the law in vogue at Delhi and its adjoining areas. So for all other purposes, my lords, the laws in Delhi would be applicable. Only the power of attorney was executed in Shillong. Now, my lords, I will take your lordship very quickly. Paragraph 10 at page 39, if your lordship see what is the cause of action for filing the complaint.
Yes.
That when things were not going in the way as stated above, the accused number 1, Deen Dayal Sharma, was not vacating the 1st floor and he was giving it a different picture in the matter of disposal of the 4th floor. Your humble complainant smelt a rat and deal with Sri Deen Dayal Sharma, her own brother-in-law, whom she and her husband had reared and groomed since his school days in the relation. Shri Ramesh Kumar Sharma decided to go in person to the spot in Delhi, but due to some personal reasons, she could not go, my lords. It's not important. We'll just skip a few lines if your lordships kindly come, my lords. 1, 2, 3, 4, 5, 6, 7, 8. 8 lines from the bottom, my lords. It's Shankar Lal Ji Pipalwa. Your lordships will find that. 8 lines from the bottom, my lords.
Yes.
Shri Shankar Lal Ji Pipalwa. He's a mediator, my lords, who's trying to mediate between both the parties. Called a family meeting on 25/12/2020 at the present residence of the accused number 1, that is Mohindru Enclave Block so-and-so, where Shri Babulal Sharma, elder brother of the husband of your humble complainant and accused number 1, as well as Shri Mohanlal Nawal, who is the husband of elder sister of your humble complainant. The accused number 1 was present along with his wife Premlata Sharma and accused number 2 and his son Saurav Sharma as well. That in the family meeting held on 25/12/2020 at New Delhi, as stated above, the accused number 1 raised certain unfounded allegations are not acceptable to your humble complainant, including those family members who were present at the meeting, because these were not supported by any document whatsoever. The accused number 1 did not raise any such issue of dispute, my lords. Again, I'll skip it, and 3 lines from paragraph 12, your lordships will see that when the discussion in the family meeting was about to be failed, then the accused number 1 in the presence of the meeting demanded a colossal amount of 1 crore from your humble complainant's husband for vacating 1st floor, which was given to him to stay for some time with his family and when the rented house at Model Colony 3, Delhi. Now, if your lordship skip, my lords, regarding the territorial jurisdiction, my lords, they say here, paragraph 17, your lordships may kindly see, at page 41.
Yes.
That your humble complainant was eager to launch a criminal proceeding against the accused persons above named before this honorable court, as the cause of action has incepted at Shillong city because the power of attorney dated 21/5/2012 was registered at Shillong, empowering the accused number 1, Deen Dayal Sharma, when he made the proposal. So the only ingredient, my lords, of whatever they are trying to say is that some power of attorney was executed in Shillong. Now, even assuming, my lords, that the power of attorney was executed in Shillong, I have to concede to that, that itself is not a criminal act. In furtherance of the power of attorney, my lords, the allegation is against me that a construction has been made. 1 floor or 2 floors were to be handed over to accused number 1 and 2, my lords. That has not been handed over to the petitioner and her husband. That has not been handed over. Now, that fact, my lords, the question I ask myself is, can a court in Shillong try that offence? because the offence of 420, 406 and 418, what has been alleged against me, my lords, before the learned trial court here, have all happened in New Delhi. And I will very quickly take your lordships to section 177 of the CRPC. Your lordships are well aware, my lords, but I'll just very quickly just take your lordships to section 177 of the CRPC.
Yes.
Ordinary place of inquiry and trial.
Please.
Well, every offence shall ordinarily be inquired into and tried by a court within whose local jurisdiction it was committed. Now, the execution of the power of attorney, my lords, is not a criminal act. The criminal act, if any, my lords, on the basis of the power of attorney, some building had been made. Now, the illegal act complained of is that that portion of the building which was supposed to be given to the petition, to the complainant, my lords, has not been given. So that cause of action arises wholly and solely in New Delhi. So therefore, under section 177, my lords, only the courts in New Delhi would have jurisdiction insofar as these offences are concerned. Now, that is one part of it, my lords. The other part of it is, your lordships will kindly see, at page 87, my lords, is the order by which cognizance is taken.
Yes.
My lords, this is order dated 18/7/2022. My lords, CR put up today, learned counsel for the complainant, Shri So-and-so present, seen forwarding report filed by OC Labang. Seen and perused the report by SI so-and-so, submitted along with statement of complainant and witnesses. Learned counsel for the complainant placed before the court that the accused may be summoned based on the report filed by the EO. On perusal of the same, this court deems it fit and proper to take cognizance of the instant case. Now, your lordships, I will very quickly just take your lordships, my lords, assuming the cause of action, my lords, was in 2012 when the power of attorney was executed. Your lordships are aware of section 368 of the Code of Criminal Procedure, my lords. If your lordships kindly quickly have a look at section 468 of the Code of Criminal Procedure, my lords. 468, my lords, 468. The limitation with regard to taking of cognizance.
Yes.
Well, it's except as otherwise provided elsewhere in the code, no court shall take cognizance of an offence for the category specified in subsection 2 after the expiry of limitation. The period of limitation shall be 6 months from the date of offence with fine only, 1 year from the offence is punishable with imprisonment for a term not exceeding 1 year, 3 years if the offence is punishable with imprisonment for a term exceeding 1 year but not exceeding 3 years. Now, my lords, section 406 and 418 of the IPC, my lords, they are both punishable with 3 years. Maximum punishment is 3 years. Otherwise also, my lords, going by the bald assertions made on the complaint, cognizance in respect of 406 and 418 could not have been taken by the learned court. There is a statutory embargo.
Yes.
What I am humbly praying before your lordships is, my lords, because notice would have to issue to the respondent before your lordships. The lordships may issue notice, and in the meantime, my lords, the further proceedings of this case may be kept in abeyance, and your lordships may decide it at an early date, my lords. That would be my respectful submission before your lordships.
Where is the latest order? Here the date fix here is 7/9/2022.
My lords, after that, the matter has been fixed on 2 or 3 occasions. My lords, those orders we have not brought it on record. It's not here.
Then
if your lordship so direct, we'll file.
Now, do we know? How do we know what is the content of the last order?
We'll file an affidavit bringing that on record, my lords. But I am here on
Not
the
necessarily.
legality of the proceedings before your lordships.
You just produce copies of this order. Yeah.
My lords, we'll do that.
Download it from the CIS.
We'll do that, my lords. We'll do that and we'll file it before your lordships.
Can you take steps, Mr. Paul? But as far as the stay is concerned, first let me have a look at the last order.
My lords, we have been summoned, my lords. We have been directed to appear before the court below.
Have you appeared?
I can say no, we've not appeared, my lords, because the proceedings are otherwise, my lords.
You've been,
the lordship will see this.
You've been
this
directed
order
to see, Mr. Paul. You've been directed to appear since September 2022.
My lords, notice was served on us very recently.
Recently.
My lords. I will place the other orders before your lordships, my lords. That will show we.
Yeah, that'll be much. You'll get a clearer picture then.
Lordships.
So you take steps for issue of notice. What, Mr.
My lords, may I pray your lordships have this matter next week, my lords, considering that there is the question of stay.
What, Mr. K. Paul?
And lordships may grant me liberty to bring those orders on record.
What, Mr. K. Paul, senior counsel appearing for the petitioner. In course of hearing, the Land Council has made a submission, rather a prayer before this court, to bring all the necessary orders of the Leonard Trial Court in a form of an affidavit before this court. In the meantime, notice upon the respondent is allowed to be issued. Petitioner to take steps accordingly. List this matter after 1 week.
Well, I'll you guys.
Item number 2.
May I please, Your Lordship? Till late, the judgment has not been served to us. So that's why we are not prepared today for the hearing.
You have not given. What is the point to be considered?
Here, my lord,
As far as the respondent is concerned?
my lord, here what happened, my lord? Notices could not be served by the trial court. my lord.
That part is.
My lord. So here, my submission before lordship was that lordship will grant us liberty to will withdraw this criminal petition, my lord, because second complaint on the same cause of action is not barred, my lord. And to that effect, I placed certain decisions of Supreme Court, my lord. To that, they were supposed to respond.
Yeah, so if you want to withdraw, what is there? What is there for you?
Your Lordship, we don't have objection if they withdraw, but they are giving like under this judgment which they have submitted before Your Lordship, they want observation. So
No,
we have.
what we'll do is, this court will allow withdrawal as and when you think fit to file another petition of whatever kind. The law will be looked into at that point of time.
But Your Lordship, just withdrawal can be done, but
withdrawal will be.
Yes, but other than that, if
in
any
my humble submission, respondent number 3 is represented, my lord. How are they making submission on behalf of somebody else? My lord,
because you will have to fight
my
your
lord,
case.
Your lordships can split the trial, my lord. As far as they are concerned, your lordship can still remand it back, my lord. You can allow my prayer to that extent, my lord. But I am not even asking for that. I am only saying that law is very clear, my lord. I placed Supreme Court decision that second complaint is maintainable. And in that view of the matter, I am seeking liberty, withdrawal with the liberty to file a fresh complaint.
that can be Your Lordship allow if they want to file with the liberty to to fresh file.
So you see, everything will be in accordance with law and procedure. So if at all they file, any application thereafter which is flawed in law, then the matter will be taken up.
If Your Lordship give any observation, then court below will take that observation as the order, Your Lordship. That's why we
Observation
have objection.
as far as the prayer is concerned is this: in most cases, you see, the mere withdrawal will not solve the problem as such. Issues are yet to be gone into, yet to be decided. Issues of facts and laws are there. So this court will not go into that aspect of the matter at this point of time. It is just a withdrawal simpliciter. If liberty is sought for, that will be given, and that too if at all filed in at any point of time, will be in accordance with law. So there you will have your defense there if you are arraigned as a party, or you may not be, for all we know. Heard, Mr. Dr.
My lord, my case was, my lord, Lord recollect, on last occasion I placed two Supreme Court decisions, my lord, which say that because my complaint has been dismissed for default by the trial court, my lord. Now we came by way of revision before this honorable court for restoration, my lord, or challenging the dismissal order, my lord. Dismissal for default, my lord. Now, in view of the Supreme Court decision, I want to withdraw this 482 petition from this honorable court, my lord, with the liberty to file a fresh complaint before the trial court.
Yes, that you do. If at all the trial court has any issue with that, then
I can come back, my lord.
Yes. Dr. Musical, you're appearing for the as a DSGI?
Yes, ma'am.
DSGI, who has submitted that this petition may be allowed to be withdrawn with liberty to file a fresh complaint for the trial court. Without going to the merits of the matter on preamble, the same is allowed. Petition is hereby dismissed as withdrawn with liberty sought for allowed.
Item number 4.
Well, only that much observation your lordship could give, my lord, that I place.
That you can do it before the trial court. Your prayer has been allowed. So how if at all you file a fresh application before the trial court, then you can place the law there.
If the trial court doesn't exceed, my lord, I'll be foreclosed from everything, my lord.
Dr. Musiga, this court cannot go into the authorities at this moment, because if that is the case, then I have to hear the matter on merits. And hearing on merits means the respondent at the bar has to be heard, and the other 2 or 3, whatever.
Well, that's the whole difficulty, my lord. If I'm left with no remedy, my lord, then
you have to come back. We'll look at it. Fine, thanks.
Item number 4.
So, that order remains.
Yes. You are given liberty to file a fresh complaint.
The respondent is represented, well, that may be reflected, well. One of the respondents is reflected.
You are paying for respondent?
3.
Ms. M. Mahanta, where counsel has appeared on behalf of respondent number 3 and has no objection to the submission.
2 and 3 both.
2 and 3. Simon.
In this matter, we have already filed an affidavit of service on respondent number 3.
Here I have the instruction to appear on behalf of the respondent number 3, Lordship. So recently I have received the photocopy of the CD, Lordship.
You are paying for respondent 3?
For the state, Lordship.
For state, you are for 1 and 2?
Yes, and I have the instruction to appear on behalf of the...
Who is respondent number 3?
He is the officer in charge.
Oh, then of course. If he's a...
Complainant come officer in charge.
Yes, Lordship.
He's a police officer.
Yes.
Here, Lordship, I just received the photocopy of the CD, Lordship. I need some time to go through the CD, Lordship. So I just pray. And in the meantime, the matter may be listed for final hearing.
How long? How long?
Yes, ma'am.
Next week?
2 weeks then.
After 2 weeks, ma'am.
Mr. S.A. Shiglarat GA has submitted that he is also entering appearance on behalf of the respondent 3. However, in the meantime, the learned counsel for the prisoner, Mr. S. Thapa, has submitted that notice has been effected on respondent number 3, and to this extent an affidavit of service has also been filed. Be that as it may, since the respondents have been are duly represented, this matter as paid for will be heard after 2 weeks.
Item number 5.
Actually, my senior is doing from VC, Your Lordship, but there is some problem, I think, is on connection. So I'll just pray that we'll second in next day, Your Lordship.
Tomorrow?
Okay, Your Lordship.
Tomorrow is okay?
Okay.
Listen.
Just want to have some other matters as well. We can have it next week if it's convenient to the court.
Since the Leonard Senior Counsel conducting the matter, who is supposed to appear through the virtual mode, could not do so, perhaps due to technical difficulties, the matter as prayed for by the Leonard Counsel at the bar will be heard after 2 weeks, you said? Or 1
week, my lords.
After 1 week.
Highly appreciated.
All right.
Item number 14.
May it please your lordship, I pray that this matter may be adjourned for the day, my lord, as the conducting counsel P. Nongri had to leave the premises due to some present
He's not here. On prayer made by the petitioner, not objected to by respondent, list this matter after 2 weeks.